Hearing the appeal for Skatteforvaltningen against Solo Capital Partners.
Good morning, my lords. My first topic is the scope of the revenue rule. And by way of introduction, may I say this: since the rule prevents a party with an otherwise admissible claim from being heard, we respectfully submit that your lordships will wish to be mindful of the limits to the rule stated in the earlier authorities, particularly at the level of the appellate committee, and very slow to expand the scope of the rule, at least without very good cause. Our submission is that the authorities establish, indeed clearly establish, that the revenue rule applies only if the claim being considered by the court is one that is made directly or indirectly for the payment of tax, which is due. If no tax is due, the claim cannot be within the revenue rule.
So that's Lord Mackay's position?
Indeed, we so submit, and it's supported by much other authority in our submission.
Would that include interest and penalties?
Yes, it would, my lord. We say, by contrast, it is not sufficient to engage the revenue rule that the claim arises in the context of tax. And for us to make those submissions is not, as my friend Mr. Beale has suggested, certainly in his written submissions, to elevate form over substance. It is to focus on the criteria which have been laid down by the appellate committee and by lower courts as to the scope of the revenue rule. We say the starting point in the modern authorities is Government of India and Taylor. And can I take the court, please, back to Government of India and Taylor, which appears in the authorities, tab 1, at authorities 1967. And as the court knows, the Government of India was seeking to enforce an Indian tax debt. Viscount Simmons began his speech for the appellate committee at authorities 1979, page 503 of the law report, with these words in the middle of the page: the questions raised in the appeal are two, whether there is a rule of law which precludes a foreign state from suing in England for taxes due under the law of that state. That's his formulation of the issue.
Lord Penning, I have a page problem. Are you giving me pages from the main hearing bundle?
It's 1979.
1979 of the authorities bundle.
Is the authorities bundle. Have you got the...
Something's gone wrong.
The case begins...
The key bundle rather than the authorities bundle.
The case begins, my lord, at authorities 1967. I don't know.
Okay, I'll try again. But don't pause.
Well, I want your lordship to be able to
I'll catch up.
Follow the case. Does your lordship have the case, but with different numbers, or does
I have a completely different case. I'll get there.
Very well, my lord. At 1979, Viscount Simmons identifies the issue, and then in the second paragraph of his lordship's speech, he says he was greatly surprised to hear it suggested the courts of this country would and should entertain a suit by a foreign state to recover a tax. And his lordship then refers to the observations of Mr. Justice Rowlatt in the Brostron case. It is perfectly elementary that a foreign government cannot come here, nor will the courts of other countries allow our government to go there, and sue a person found in that jurisdiction for taxes levied and which he is declared to be liable to in the country in which he belongs. And then there's a reference to Mr. Justice Tomlin in re Vissa, and over the page, similar principle, well-recognised rules, the third line, which has been enforced for at least 200 years, under which these courts will not collect the taxes of foreign states for the benefit of sovereigns of those foreign states. So that's Viscount Simmons' understanding of the nature of the principle. At 505, in the final paragraph of the page, which is Authorities 1981, his Lordship refers to the observations of the advocate Sir Andrew Clark, who argued the case for the appellant with vigour and candour, admitted that he knew of no case in which a foreign state had recovered taxes by suit in this country, nor of any case in any foreign country in which the government of the country had done so. At 508, which is Authorities 1984, in the first new paragraph, there's a reference to the Buchanan case, to which I will come. On the next page, Authorities 1985, Lord Morton and Lord Reid concur, and Lord Keith's speech begins at the bottom of 1985, and he too agrees with Viscount Simmons. And at the top of 1510, there's the reference to the Buchanan case, to which I will come. And at the end of page 1986, the last four lines, on the other hand, he, that's the judge in Buchanan in Ireland, held that although the action was in form an action by the company to recover these assets, it was in substance an attempt to enforce indirectly a claim to tax by the revenue authorities of another state. Then over the page, at 1987, page 511, Lord Keith addresses the rationale of the revenue rule, and your lordships have seen this. It's an extension of the sovereign power which imposed the taxes, and there's then an alternative explanation, but it's the sovereign power explanation which has gained the support of Lord Gough in the Norway case, Authorities page 2088, and also, as Lord Gough noted, the agreement of the editors of Dicey at Authorities 2353 to 2354. This rationale for the revenue rule has also received the support of Lord Kitchin for the board in Webb, which my friend Mr. Beale took the court to, which is Authorities 2178, paragraphs 32 and 55. Just completing Government of India, if your lordships please turn on to Authorities 1989.
Sorry,
1989. Bottom of the page, your lordships see the speech of Lord Somerville, and in the second paragraph, the final paragraph on that page, his lordship says the first issue is whether a foreign state can use the courts of this country for the collection of its taxes. And over the page, page 1990, in the first new paragraph, there's no decision binding on your lordship's house, and then he says if one state could collect its taxes through the courts of another, it would have arisen through what is described vaguely perhaps as comity or the general practice of nations. The appellant was therefore in a difficulty from the outset, in that after considerable research, no case of any country could be found in which taxes due to state A had been enforced in the courts of state B. One other passage in the report that may interest the court, if your lordships would turn back to 1976, page 1, authorities 1976, your lordships will see the argument of counsel for the respondents, which begins at the bottom of page 1975. Mr. Millard Tucker, Raymond Jenkins QC and Oliver Smith. And I draw attention to this because at 1976, in the final 6 lines, picking up 6 lines from the bottom of 1976, counsel's argument was this: the position would not be the same as the present if, after the Indian government had obtained possession of a taxpayer's money, it was stolen by a thief. The government could sue to recover it in this country. We draw attention to that, and I'll make submissions on the analogy in a while. So in my submission, Government of India is a case that recognises that the revenue rule is concerned with a claim for the recovery of taxes which are due. The Buchanan case is of interest and importance because it was a case where taxes were due and the claim was seeking indirectly to enforce the unsatisfied foreign tax debt. Buchanan appears in the law reports after Taylor. We have it.
Lord Panic, Buchanan. Not Buchanan, Buchanan.
Buchanan, thank you, my lord, thank you. Buchanan. Buchanan appears in Authorities tab 8 at page 2279. May I ask if my Lord Briggs...
It's all right, I'm on course now.
I'm very grateful. 2279 is Buchanan, and your lordships have seen this. It's a case where the claim was brought by a liquidator who's appointed by the foreign revenue, by which I mean the non-Irish revenue, as the only creditor of the foreign company. The businessman in Scotland, he'd entered into a scheme to avoid a retrospective tax, and he'd moved to Ireland, as we see from page 2280 in the final complete paragraph on page 2280. And the Inland Revenue had taken action to wind up the company, and the liquidator, and that appears at the bottom of 2282, and the liquidator had then brought these proceedings. So the liquidator, as we're told, at 2283, in the first new paragraph, lines 5 to 6, the liquidator was working hand in glove with the authorities in an effort, quote, to chase the tax. And Mr. Justice Kingsmill accepted that this claim fell within the scope of the revenue rule, as we see at page 2292 of the authorities.
I see the liquidator was described as a financial Sherlock Holmes.
Yes, indeed. At 2292, in the final completed paragraph, his lordship says in the third line, it's not a question whether the plaintiff is a foreign state or the representative of a foreign state or its revenue authority. In every case, the substance of the claim must be scrutinised, and if it then appears it's really a suit brought for the purpose of collecting the debts of a foreign revenue, it must be rejected. And then there's a sentence, and then this: for the purpose of this case, it's sufficient to say that when it appears to the court that the whole object of the suit is to collect tax for the foreign revenue, and this will be the sole result of a decision in favour of the plaintiff, a court is entitled to reject the claim by refusing jurisdiction. The case then went to the Supreme Court of Ireland, which upheld the judgment of Mr. Justice Kingsmill Moore, and at page 2296, in the first new paragraph on page 2296, near the end of that paragraph, 4 lines from the end, Chief Justice Maguire says the position seems clearly to be, as found by the trial judge, that these proceedings were started in Scotland with the purpose of collecting a tax. And then in the next paragraph,
Yes, he seems to be saying that the only creditor who benefited from the liquidation was the revenue.
Indeed. And that's what has been found by Mr. Justice Kingsmill Moore earlier on in his judgment.
I'm not sure it was a good point, because the revenue could, of course, prove in the liquidation in Scotland. Actually, the non-revenue creditors would be out of pocket.
I see. Yes. Well, I'm sure you're all right. That's the basis upon which the case has proceeded. Yes. In any event, that was the object of the claim in Ireland, was to, and this is what Chief Justice Maguire says at page 2296 in the second new paragraph, the middle paragraph, some 6 lines up from the end of that paragraph. In these circumstances, the conclusion of fact at which the judge arrived that the sole object of the liquidation proceedings in Scotland was to collect a revenue debt, and that apart from the costs and expenses, any monies received would inevitably pass to the revenue, was amply justified. So that's the basis upon which the case proceeded. The appeal was dismissed.
Yes, if there were other creditors, the fact that a particular petitioning creditor was in effect winding up wouldn't necessarily give rise to the same result. But I'm not sure it's a matter we need to go into.
I don't think it is, my lords. It suffices that the purpose of the claim in Ireland was to satisfy a tax debt, that is, tax owing by the individual to the Inland Revenue in Great Britain. That suffices. Now, what we do accept, of course, is that Buchanan supports the proposition, establishes the proposition that Dicey Rule 21 prohibits a claim to collect tax owed, whether that is direct or indirect. We accept that. And we also accept a point that was emphasised by my friend Mr. Beale, that is so, the revenue rule applies even where the taxpayer has acted in a fraudulent manner. Our point is that Buchanan, like all the other revenue rule cases, depends on the claim being, directly or indirectly, a claim for taxes due. It is only if there are taxes due, and if the claim seeks to recover those taxes due, that the revenue rule applies.
Yes, as I understand your case, you're not asserting that fraud makes a difference. You're asserting that the key point is there has to be taxes due.
Indeed. If the claim, directly or indirectly, is for taxes due, then fraud does not take the case outside the revenue rule.
In short, it applies to fraudulent tax evasion.
Yes.
Because evasion encompasses the concept that some tax is due.
Precisely so. So long as there are taxes due. The existence of fraud may, however, be relevant. It may help to establish that the claim is not for the recovery of tax due, which is our submission in this case. And I'll come on to the circumstances of this case in a moment. But I make it very clear, as we have throughout, that it is not our submission that if the claim, directly or indirectly, is for taxes due, then fraud cannot assist.
I mean, the distinction you're drawing is between fraud in relation to taxes that are due and fraud which involves someone impersonating a taxpayer.
Precisely.
Yes.
So that's Buchanan. The cases of Government of India and Buchanan were addressed by Lord Mackay and also by Lord Templeman in their speeches for the Appellate Committee in the Williams and Humbert case. And Williams and Humbert appears the relevant passages start at authorities 2205. And as the court has seen, Lord Mackay's speech had the agreement of Lords Scarman, Bridge and Brandon. They all agreed with Lord Mackay at page 2262. Lord Mackay set out the rule in Dicey at page 2274 at the beginning of his speech. On that page 2274, Lord Mackay then addresses Government of India and Buchanan. He identified the question raised in Government of India at 2274 at letter G, at page 2276 at letter A, His Lordship referred to Buchanan. At 440, which is page 2277, letter D and following, Lord Mackay set out the argument which was being advanced in the Appellate Committee in reliance on Buchanan. At letter D, 2277, from the decision in the Buchanan case, counsel for the appellant sought to derive a general principle that even when an action is raised at the instance of a legal person distinct from the foreign government, and even where the cause of action relied upon does not depend to any extent on the foreign law in question, nevertheless, if the action is brought at the instigation of the foreign government, and the proceeds of the action would be applied by the foreign government for the purposes of a penal, revenue, or other public law of the foreign state, relief cannot be given. So that was the argument that Lord Mackay was addressing. Lord Mackay then referred to the circumstances of Buchanan, and just above G, on page 2277, Lord Mackay said this: most important, there was an outstanding revenue claim in Scotland against the company, which the whole proceeds of the action, apart from the expenses and the liquidation, would be used to meet. No other interest was involved. This was regarded as of critical importance. All of which is correct. And then Lord Mackay sets out his answer. Having regard to the questions before this House and Government of India, I consider, he says, that it cannot be said that any approval was given by the House to the decision in Buchanan, except to the extent that it held that there is a rule of law which precludes a state from suing in another state for taxes due under the law of the first state. And he refers to two other cases, Rossano and Brokow. And as he states, those cases do not support the suggestion that an action in this country could properly be described as the indirect enforcement of a penal or revenue law in another country when no claim under that law remained unsatisfied. The existence of such unsatisfied claim to the satisfaction of which the proceeds of the action will be applied appears to me, says Lord Mackay, to be an essential feature of the principle enunciated in Buchanan for refusing to allow the action to succeed. And it is plain in my submission that what Lord Mackay is there saying, where he refers to claim, is what he has defined on the previous page at 227 letter H, that is suing in another state for taxes due under the law of the first state. And our submission is that that is the ratio, or one of the ratios, of this judgment, of the speech, that the existence of an unsatisfied tax obligation and the fact that the claim is to satisfy that tax obligation is, quote, an essential feature of the revenue rule. Mr. Beale argued that it's not part of the ratio, and he gave a number of reasons. He said, first of all, that the case was not concerned with a tax claim, it was concerned with penal laws. But with great respect, that won't do, because Lord Mackay is giving his reasons for rejecting the submission which he set out at 440 D to E, that's 2277 D to E, which covers the revenue rule as well as the penal aspect of Dicey, what is now Dicey Rule 20. And Lord Mackay sets out why he rejects that submission in the terms that I've read out. And in any event, Dicey Rule 20 developed out of cases which concerned penal laws. The revenue rule developed out of the cases concerning penal laws, as we explain in paragraphs 57 to 61 of our written case. Then my friend said that Lord Mackay was responding to what he described, what my friend described, as an overbroad formulation by counsel. But the point, what matters, are the criteria stated by Lord Mackay, who has formulated the scope of the revenue rule for the appellate committee. And finally, my friend said Dicey does not treat Lord Mackay's statement as altering the revenue rule, to which our response is that we are not submitting that Lord Mackay's statement alters the revenue rule. Our submission is that Lord Mackay states what was already recognised in Government of India and indeed in earlier cases. And one sees this if we look, please, at the relevant passage in Dicey. Dicey appears behind tab 11 at page 2348 of the authorities, and the relevant passage in Dicey begins at 2358. Authorities 2358, it's paragraph 8-009, side heading revenue laws. And Dicey sets out almost a century ago, it was said that there is a well-recognised rule which has been enforced for at least 200 years or thereabouts, under which these courts will not collect the taxes of foreign states for the benefit of the sovereigns of those foreign states. This is because tax gathering is not a matter of contract, but of authority and administration, as between the state and those within its jurisdiction. Accordingly, says Dicey, the courts do not enforce foreign revenue laws nor judgments based on foreign revenue claims. And the footnote references are to the earlier cases, such as Visa, Government of India, etc., etc. So there's nothing surprising in my submission about what Lord Mackay says for the Appellate Committee. And as I'll show the court in a few moments, in the Court of Appeal, Lord Justice Simon Brown, in the QRS case, understood Lord Mackay as stating the criteria for the application of the revenue rule. My friend Mr. Beale mentioned in passing yesterday a commentary by Professor Adrian Briggs. He referred to it, I may say so in rather disparaging terms, but there it is. Professor Briggs is a distinguished academic. And I won't invite your lordships to read it now, but I do commend it to the court. It appears in the authorities tab 114 at page 5456. And Professor Briggs refers to Lord Mackay's statement of principle as, quote, precise and careful. And Professor Briggs then expresses his opinion that the Court of Appeal judgment in the present case was, in his words, plainly right, which I'll come on to if I may. Can I also take the court, please, to what Lord Templeman said in Williams and Humbert? Lord Templeman's speech also had the agreement of Lords Scarman, Bridge and Random. At page 428 of the law report, which is authorities 2265, at letter F, the paragraph at letter F on 2265, Lord Templeman says there's another international rule whereby one state will not enforce, and I emphasise that word, the revenue and penal laws of another state. And Lord Templeman says in the final sentence of that paragraph, the international rule with regard to non-enforcement of revenue and penal laws is absolute. There's no dispute about that. It's an absolute rule. And that's, in my submission, another reason why we respectfully submit that it's important not to expand the scope of the revenue rule beyond established boundaries. It is an absolute rule. Lord Templeman dealt more briefly than Lord Mackay, but to like effect as Lord Mackay, with Government of India and Buchanan. Lord Templeman referred to Government of India at authorities 2269, and on the same page, just above letter H, Lord Templeman referred to Buchanan. And on page 2270, just below letter B, Mr. Lippman, Mark Lippman, counsel, relied heavily on Buchanan, which he said applies to the present case because the object of the plaintiffs in the trademark action and the bank's action is to collect assets which will indirectly inure for the benefit of a foreign government. In my opinion, says Lord Templeman, the Buchanan case only concerns a revenue claim. And then his lordship defined what he meant. The principle that a country cannot collect its taxes outside its territories cannot be used to frustrate or contradict the principle that the courts of this country will recognise the law of compulsory acquisition of a foreign country of assets within the foreign country and will accept and enforce the consequences of that compulsory acquisition. So again, there's a statement as to what the revenue rule covers, cannot collect its taxes abroad. Mr. Beale also referred to the advice of Lord Kitchin for the board in Webb and Webb. And I take your lordships back to Webb. This was the family law case, and it appears behind tab 6 of the authorities, starting at page 2178. And the relevant passage in the advice of Lord Kitchin for the board is at paragraph 32, which is on page 2183. 2183. And at paragraph 32, Lord Kitchin says, "It is a long-standing principle of the common law that the courts will not collect taxes of a foreign state for the benefit of the sovereign of that foreign state." That's Lord Kitchin's understanding for the board of the principle. Then my friend Mr. Beale took the court to the judgment of Lord Justice Simon Brown for the Court of Appeal in QRS 1 and Franzen. This is authority number 45 at page 3784. Can I take the court, please, to QRS 1, 3784, Court of Appeal. And again, this was a liquidation case. The liquidator of Danish companies had brought proceedings, as we see from the headnote, in this country to recover sums from the defendant, the former owner of the companies, who was accused of asset stripping. And the only creditor in whose interest the liquidator was acting was the Danish tax authority, as we see from page 3787 at letter E. And Lord Justice Simon Brown set out at 3786 letter G, Rule 3 as it then was, of Dicey and Morris. And as he said at letter G, it's clear the present action falls foul of that rule. It involves the indirect enforcement of Denmark's revenue rule. At 3787, as he says, the facts were in all material respects indistinguishable from those in Buchanan. And at 3788, between letters E and F, his lordship says it can be said of the plaintiff's claim here, as it was said of the liquidator's claim in Buchanan, that the whole object of the suit is to collect tax for a foreign revenue, and this will be the sole result of a decision in favour of the plaintiff. If your lordships then turn on to 3791, at the top of the page, his lordship refers to one other aspect of the plaintiff's arguments. Mr. Vida sought to submit that Rule 3 of Dicey and Morris, at any rate insofar as it extends to indirect enforcement, is a product of its times, no longer to be regarded as sound, least of all in a community law context. And then in the next paragraph, Lord Justice Simon Brown says, to my mind, however, there's nothing in this argument. Mr. Vida was unable to formulate satisfactory limits to the rule's application. I repeat, he says, as late as 1990, the House of Lords was continuing to describe the rule in the Norway case as a fundamental rule of English law. All that said, I, for my part, would wish to emphasise the relative narrowness of Rule 3, insofar as it applies to this particular kind of indirect enforcement. And his lordship then set out what Lord Mackay had said in Williams and Humbert, and over the page at 3792, letter B, his lordship said, I can readily understand Lord Mackay's insistence on the narrowness of the Buchanan decision, and his approach appears consistent with the views of Cheshire and North. So far from assisting my friend, QRS1 APS supports our approach to the scope of the revenue rule. My friend, Mr. Beale, also made reference to the judgment of my Lord Lloyd Jones for the Court of Appeal in the Ben Nevis case. That too was a claim for taxes due. I don't invite the court to turn it up. It's Authorities, tab 20, page 3022. We see from paragraph 1 that there were taxes due. And the revenue rule did not apply because there was an international agreement allowing for claims to be brought here, paragraphs 3 and 6. And indeed, as your lordships will have seen, in Government of India, Lord Keith refers to the rule as applying, the revenue rule as applying, quote, treaty or convention apart. It's Government of India, Authorities, page 1987. My friend Mr. Beale was then asked by your lordships whether he could cite any authority in which the revenue rule had been applied where there was no claim for taxes due. And his answer, my friend's answer, was to place reliance on two United States authorities, Reynolds Tobacco and the Nabisco case. And I'll take your lordships to those. My submission is that neither of those cases assists my friend, because in each of them the United States authorities were claiming a remedy by reference to taxes due and not paid. They were claims indirectly to meet taxes that were due and had not been paid. The first of the cases, the Reynolds case, is at Authorities tab 67. And that appears in the Authorities bundle at 4616. It's a judgment of the United States Court of Appeals for the Second Circuit, the Reynolds case. Could I just invite your lordships to note in passing the composition of the court at the bottom of 4616, because the court included District Judge Kaplan, and if you turn over the page, please, the court will see who that was. It was the Honourable Lewis A. Kaplan of the United States District Court for the Southern District of New York, sitting by designation. And I emphasise that because it was Judge Kaplan who decided the Scat case, our case, in the United States District Court and made observations consistent with my submissions on the scope of the revenue rule, and I'll come to that. But he was a member of this this court. And he commented indeed on the Reynolds case. The passages that I draw attention to are 4617, authorities 4617 in the leading judgment, in fact I think the only judgment, of Circuit Judge Katzmann, who explains this action was brought by the Attorney General of Canada on behalf of the Government of Canada for damages based on lost tax revenue. And he explains what had been going on, smuggling of cigarettes across the border. Canada seeks revenue that it lost from the evasion of tobacco duties and taxes. And then he says in the next paragraph, the case involves the construction of RICO in light of the common law doctrine known as the revenue rule, long established feature of the law of the United States and other nations, including Canada, which holds that the courts of one sovereign will not enforce the tax judgments or claims of another sovereign. And he gives some detail, and then 4 lines from the end of the paragraph, we have no choice but to conclude that RICO may not be used by Canada to seek recovery of lost tax revenues and tax enforcement costs as RICO damages. We therefore affirm. And there's one other passage at 4640 in the penultimate paragraph, which begins as to direct enforcement. There's a reference to a Canadian Supreme Court case of Harden, which said we must look to the object of the claim. When we do so, we see that at bottom, Canada would have a United States court require defendants to reimburse Canada for its unpaid taxes plus a significant penalty. Thus, Canada's object is clearly to recover allegedly unpaid taxes. That's what the case was about. And that's why the revenue rule applied. Similarly, the other case on which my friend relied, the Nabisco case, which appears behind tab 71 at authorities page 4675, and the head note at the bottom of 4675, the holding rather, in the last 3 lines of 4675, makes clear what the position was. RICO barred civil suits by foreign governments claiming violation of their tax laws, the whole purpose of which was the collection of tax revenue and associated costs. And at 4678, just at side letter B, 4678 at B, the complaints all sought to recover treble damages pursuant to RICO for duties and taxes not paid on the cigarettes. And at 4682, at the bottom of the page, the final 2 lines on 4682 of the judgment, we're told, but the whole object of the present suit is to collect tax revenue and the costs associated with its collection. So those 2 authorities, which were the answer given by my friends to the question, are there authorities which support his proposition that the revenue law applies more widely than we have contended? Each of those cases is a case indirectly to recover taxes due and owing. And this was addressed by the Chancellor in the Court of Appeal. If your Lordships have the key documents bundle, It's at tab number 5, the judgment of the Court of Appeal, and the relevant passage is at page 169, paragraph 134, where His Lordship the Chancellor says for the Court of Appeal, key documents 169, paragraph 134, the US federal authorities relied upon by Mr. Beale, Canada, that's the Reynolds case, there's another one, Honduras and Nabisco, and nothing to the point. They're all cases which were fairly and squarely within the revenue rule because they were claims to recover unpaid tax. And the fact there'd been fraud in evading tax did not take the case outside the revenue rule, etc., etc. And there's a reference to my acceptance on behalf of the claimant that fraud does not take the case outside the revenue rule if it's a claim for taxes due. So we respectfully submit that all of those authorities are to like effect, and they all establish that the revenue rule is a rule that applies, and only applies, where there is an unsatisfied demand for tax under the foreign law, which the proceedings in this country are seeking, directly or indirectly, to recover. And I did not understand my friend Mr. Beale to invite this court to depart from Government of India or indeed from Williams and Humbert. Can I also draw attention to two recent judgments accepting SCAT's submissions to that effect, one in the United States and one in Malaysia, because, as Mr. Beale said, we, SCAT, have brought proceedings in other countries. The New York Federal District Court case appears at tab 9 of the authorities. Sorry, I didn't mean tab 9. Yes, I do mean tab 9 of the authorities, at authorities 2298. And this is the United States District Court for the Southern District of New York in 2019. And as your Lordship see on page 2298, on the right-hand column, 4 lines up from the end, it's Lewis A. Kaplan, Judge Lewis A. Kaplan, who was decided. He is, your Lordships may know, he's a very senior judge of that court who has heard a number of important cases. Indeed, he happened to be the judge who was hearing the proceedings brought against Prince Andrew, which were settled last year or the year before. And Judge Kaplan rejected the argument that was presented on behalf of the defendants that the revenue rule applied to SCAT's claim, and we see that at page 2306 of the authorities, 2306. In the left-hand column, the first new paragraph, defendants, relying on the revenue rule, seek dismissal of these actions at the outset. If plaintiff can prove that the defendants never in fact owned the relevant Danish stocks, and the court is obliged to accept their allegations as true for present purposes, the revenue rule would not apply, because the substance of the claims would be for garden variety commercial fraud. Accordingly, the motion to dismiss is denied. Whether in light of discovery, further presentation, the revenue rule will be of greater aid to the defendants, must await developments. And his Lordship developed the point.
Does garden variety have some special meaning?
Well, it means according.
Common or garden.
Well, yes, it may be common or garden.
Yes.
Yes.
That's the English equivalent, indeed.
I'm
not aware.
I wasn't missing something.
No, I'm not aware that garden variety is a particular term of art in civil litigation in the United States that means other than common fraud. And I believe, I need to find the reference, but that's what was said by the Chancellor in the Court of Appeal. Yes, the Chancellor, paragraph 135 of his judgment, key documents, page 170, referred to this and said it's what we would call on this side of the Atlantic common or garden or ordinary commercial fraud, not tax fraud. That's the reference. Judge Kaplan then, at page authorities 2309, in the right-hand column, the first new paragraph said this: these actions plainly do not seek direct enforcement of Danish tax law. The defendants attempt to frame them as seeking to recover lost tax revenue when the only reason the money was lost is because the defendants in effect allegedly stole it, and the only reason it supposedly concerns tax revenue is because the defendant's alleged victim was the Danish tax authority is too clever by half. And then at the end of that page in the right-hand column, Judge Kaplan says each case they, that's the defendants, cite and discuss in support of their position involves an underlying scheme of tax evasion. And if the court looks at footnote 42, one of the cases after Philip Morris, 3 lines from the end of footnote, well, on that page, 3 lines from the end, is the Canada case. That's the Reynolds case, involving an action brought by Canada under RICO to recover revenue that it lost as a result of the alleged conspiracy. And as I indicated, Judge Kaplan sat in that case. May I just mention incidentally, at one stage yesterday afternoon, my friend Mr. Beale referred to the views of the IRS, which in my submission are far from determinative, not least because the United States District Court has explained its view as to the nature of the proceedings. There's also a mention at 2317, since the court has this open, at the bottom of 2317 on the right-hand column, the judge says, refers to the US-Denmark Treaty, to which my friend also referred, and its provisions for assistance in the collection of a revenue claim. The judge says that's irrelevant because the plaintiff's claims do not seek to collect tax owed by the defendants and covered by the treaty. And then he explains what is covered by the treaty, and at the end of the paragraph on page 2318, left-hand column, first paragraph, money obtained by fraud from SCAT is none of these things.
Sorry, Lord Penny, my fault. That passage is 2317, right-hand column.
Yes.
2318.
Well, 2317, it starts, bottom of the right-hand column is numbered paragraph 18. There's a reference to the US-Denmark Treaty, which the judge says is irrelevant because at the top of 2318, plaintiff's claims do not seek to collect tax owed by the defendants and covered by the treaty. And at the end of the paragraph, the judge says money obtained by fraud from SCAT is none of those things. To like effect, if the court needs it, is the view of the Malaysian Court of Appeal. That appears in the next tab, tab 10, beginning at authorities 2325, when SCAT sued in Malaysia. And again, the defendant sought to set aside proceedings. They were seeking to set aside freezing injunctions and search orders on the basis that the revenue rule applied, and the Malaysian Court of Appeal rejected that submission for very similar reasons. If the court looks at authorities page 2342, the court will see reference to Government of India. There's also a reference to the Mbasogo case, which Mr. Beale took the court to. Paragraph 80, the Malaysian court says the question of whether a claim infringed the revenue rule is by determining the substance of the claim rather than its form. Based on the appellant's pleaded case and evidence, we have considered opinion. The claim filed is the appellant's attempt to seek redress and remedies under the laws recognised by Malaysia, in particular the tort of deceit, fraudulent representation. It's not based on a debt accruing from taxes due and owing or tax evasion under the tax regime of the Kingdom of Denmark. And over the page, 2343, the respondents never owned Danish shares and were therefore never within the Danish tax regime to begin with. And then there are quotations from the Scat case in New York. And at paragraph 85 on page 2343, the appellant's claim for the recovery of these monies, property, is therefore no different from that which could be brought by any private individual or entity being the victim of a fraud. In the light of the foregoing, the revenue rule has no application. So this is all much of a muchness in my respectful submission. And that was the reasoning of the Court of Appeal. I won't take time on it. Paragraph 128. I say in every case to which the court has been referred, and indeed which we have found, where the court has held claims to be inadmissible by reason of the revenue rule, there has been an attempt, directly or indirectly, to collect outstanding tax which was due. Mr. Beale made a submission on the policy reasons for the revenue rule. In my submission, this doesn't assist your lordships because the scope of the revenue rule is as we have submitted based on the authorities. It concerns claims to recover tax due. Insofar as the court is assisted by seeking to ascertain the purpose of the revenue rule, Lord Gough has addressed that question, as I said, in the Norway case. Authorities, page 2088, and Lord Gough's answer and the answer of Dicey is consistent with our submissions as to the scope of the revenue rule. My friend suggested that there might be another justification. He suggested potential embarrassment in the courts of this jurisdiction determining issues concerning foreign law. My lords, the English court often decides issues of foreign law, sometimes difficult issues of foreign law, and often issues which may cause embarrassment to the foreign state. One only has to think of extradition cases, or indeed asylum cases, where the courts here may be very critical indeed of the content of the foreign law, or indeed the way it's administered, or the performance of the foreign judiciary. So that doesn't take the matter any further, nor does the suggestion of comity. Comity cannot bar an otherwise admissible claim. We don't have it in the authorities, but there is an authority on that. The Court of Appeal in A Limited versus B Bank, which is reported in 1999, 111, International Law Reports 590.
I seem to recall I was counsel in that case.
I think it was. Lordship is familiar. I hope I've accurately summarised. So I can't remember whether your lordship was so submitting or seeking to resist that proposition, but
we lost.
Well, I think you're giving us a citation because it's not in the bundle, is that right?
yes. Can I give you a citation again, then? The case is A Limited versus B Bank. It's reported in 1999, volume 111, of the International Law Reports, ILR, page 590, and I specifically refer to the head note to the judgment of Lord Justice Leggett, 598, and the judgment of Lord Justice Morritt, 602 to 603. I should add, my lords, there is, we say, a very good reason why the revenue rule does apply only where the claim seeks to recover sums due under the foreign revenue law. The revenue rule does not have a broader scope because it's very well established that the revenue rule does not prohibit the courts from recognising foreign tax law. The revenue rule, like the penal aspect of Dicey Rule 20, only prohibits the enforcement of foreign tax law. And that principle is not in dispute in these proceedings. It's part of the, quote, high-level statements of principle which were agreed. As your lordships will recall, paragraph 9 of the Court of Appeal judgment, key documents, page 134, it's paragraph 9, Roman 6. There's a great deal of authority to support that proposition that the revenue rule and the penal rule are only concerned with enforcement, not with recognition. It's not in dispute, and my friend has made no submissions to the contrary. That's what I wanted to say, my lord, on the scope of the revenue rule. My second topic concerns the application of that principle to the circumstances of this case. And we say, to use the language of Lord Mackay in Williams and Humbert, on our case, there are no taxes due. There never were any taxes due under the law of Denmark. And we're not suing to recover taxes that are due. As the court has seen on our pleaded case, there were no shares, there were no dividends, there was no tax, there was no withholding of tax. On the contrary, our case, which of course we have to prove at trial, is that the sums paid out were induced by fraudulent misrepresentations when there was no tax due and no tax withheld.
I had possibly mistakenly thought that there were shares, there was a dividend, but these defendants were not the shareholders or the taxpayers.
Yes, there were no relevant shares, no relevant.
Well, there were. I thought there were relevant dividends and withholding tax was collected.
Yes, it was collected, but it wasn't. They weren't shares that were owned by the.
No, sure. The shares were just owned by somebody else.
Yes. Oh, certainly. They
may or may not have had repayment claims.
Yes. But for the purposes of the applicants who applied for the refunds, there were no shares, there were no dividends, there was no tax, there was no withholding tax, in respect of which the applications were made for refunds, and in respect...
That's the point. Your case is they didn't own the shares, they didn't receive the dividends, and the company wasn't taxed in respect of their shares.
That's our case.
Yes.
Well, we need to prove that, of course, at trial, but that is our case. And the claim which we are bringing in this jurisdiction to recover the sums which we paid out are not claims directly or indirectly for any tax which is due. There never was relevant tax due, and it isn't due now. That's our case. And if I'm right in relation to the scope of the revenue rule does not apply in the circumstances of this case. The liabilities which we assert and in respect of which we are bringing claims, that is a liability to pay damages or make restitution, lacks the characteristics of a tax. It's not a liability which arises from a charge imposed by the state. It is, by contrast, a liability which arises on our pleaded case from the appellant's own alleged wrongdoing. My friend emphasised that SCAT treated the applicants as taxpayers, he says, in that refunds were paid. Well, there's no dispute that the appellants and the applicants certainly deceived SCAT into thinking that they were entitled to a refund. But the misrepresentations, fraudulent or otherwise, cannot, in my submission, alter the true characterisation of the claim brought by the victim, SCAT, to recover the sums paid away. And this was addressed by the Court of Appeal at paragraph 136. The Lordships would go to key documents, page 170. Key documents 170, paragraph 136, deals with a submission made by Mr. Zellick, who was dealing with who was representing some of the defendants. His submission was that by making applications for refunds, the solo applicants brought themselves within the Danish tax system and became Danish taxpayers, and the Court of Appeal says that's misconceived. As the Court pointed out during the course of argument, their applications were all based on the lie that they paid tax in the first place, which on SCAT's case they had not. The attempt to characterise themselves as taxpayers cannot possibly bind SCAT as the victim of their fraud, and the alleged fraud defendants cannot seek to take advantage of their own wrongdoing to bring themselves within Dicey Rule 3. We say precisely so. All that my friend Mr. Beale establishes is that the deception, the misrepresentations, were successful. That does not transform the applicants for refunds into taxpayers, and far less can it establish that these proceedings are a claim for tax due.
Does the same apply for negligent misrepresentation?
Yes. Yes, it doesn't matter whether it's fraudulent or simply a negligent misrepresentation. Nor in my submission does the appellant's use of the term, quote, tax fraud, unquote, assist in analysis of this case. It is elementary in our case that the appellants used the Danish tax system as the mechanism by which the fraud was perpetrated, the alleged fraud was perpetrated. And the victim, the alleged victim, was a tax authority. But those matters do not and cannot mean that the claims brought in these proceedings are claims for taxes due, because on our case there are none. And the matter was analysed by the Chancellor for the Court of Appeal at key documents 167, starting at paragraph 126 through to 128.
Sorry, Court of Appeal, paragraph 167.
126 until 128. It starts at key document 167 over to key documents 168. I won't read all that out, but, and your lordships, I'm sure, have read it. The 126, 127 and 128 essentially sets out what the submission that I've made, and indeed made to the Court of Appeal. And the Chancellor summarised the position at key documents 172 at paragraph 143. Key documents 172, paragraph 143. As Lord Justice Phillips put it during the course of argument, it's important to have in mind that SCAT's claim is one for repayment, and what SCAT is saying entitles it to repayment is not that the applicants or the alleged fraud defendants owe it tax or have cheated it out of tax, that it was induced by fraudulent misrepresentation to pay away monies to those persons to which they were not entitled on any basis. SCAT had been paid all the tax to which it was entitled by the genuine shareholders, whilst because it was induced to do what it did by fraud, SCAT thought it was making repayments or refunds to the applicants. They were not, in fact, repayments or refunds at all, but abstraction of money by the fraudsters, as I've said, in the same way as if they'd broken into SCAT's safe and stolen the monies. The suggestion by Mr. Zellick that somehow by making the claims to monies to which they were not entitled they became Danish taxpayers is without merit, and even if there were anything in the point, it would not alter the fact that the claim is not one for repayment of tax or otherwise a claim to enforce a sovereign right, but a claim as a victim of fraud to reimbursement of the monies of which it has been defrauded.
Did the judge find that SCAT had been paid all the tax to which it was entitled? Where does that come from?
Well, that was all agreed, or was asserted by us in the pleading? Yeah, well, I'm told by Mr. Goldsmith, who appeared before Mr. Justice Andrew Baker, that this was common ground.
So it might have been by or on behalf of the relevant shareholders, because in fact it was all collected by withholding tax.
That is true, Lord.
Actually paid by the company.
That is true.
Yes.
But it's I mean, SCAT's position is that it was in fact paid all of the money that it was entitled to receive.
For all we know, may have made repayments to foreign shareholders under relevant double taxation.
Well, it's very likely that it did.
Yeah.
Extremely likely that it did. And of course, the fact that it's a withholding tax made it much more likely that it would receive all the money to which it was entitled, because the Danish companies had an obligation to pay out to SCAT. The appellants also say that after the payment out of the refunds, there was, as they put it, a hole in the tax revenues which SCAT is now seeking to repair. But it's the same point that on our case, we did receive the full amount of tax to which we were entitled. It is true that the Danish state now has, as a result of the misrepresentations leading to the payments out, a lower amount of funds than would otherwise be the case. But that does not entail that these claims to recover the sums paid out are claims for taxes due for all the same reasons. And again, there would be a similar so-called hole if the appellants had tunnelled into the office of SCAT and stolen money from the safe, or they'd hacked into our bank account and siphoned off 1.4 billion pounds worth of funds. Mr. Beale also made a point. He said, well, if you look at the 7th amended particulars of claim, SCAT has said it will give credit in calculating the quantum of damage for any recoveries made from co-tortfeasors. That, with great respect, is a bad point. That's a simple consequence of suing co-tortfeasors. we can't recover the same amounts twice. But it tells the court, in my submission, it tells the court nothing about whether SCAT is claiming for taxes due. Then Mr. Beale drew attention, or indeed he put it at the forefront of his case, he drew attention to the article by Lord Collins in the Law Quarterly Review in relation to the Sunico case in the Court of Justice. And the article, perhaps we could go back to the article, it appears behind tab 116 in the authorities at 5491. Page 5491, enforcement of foreign revenue rules. And the point that Lord Collins is making is that the Sunico case would have been decided differently under the revenue rule. That is, it would have been decided that the revenue rule did apply, because this was a claim indirectly to recover taxes which were due. If one looks on page 5491, in the middle of the page, there's the paragraph beginning "in litigation in England," which is the subject of this note. The revenue claimed that a Danish company, Sunico, had been party to a fraud in the supply of mobile phones, and that the revenue had been deprived of £40 million in unpaid VAT. And then the next paragraph, in the course of the English litigation, the revenue sought and obtained attachment orders from a Danish court over the assets belonging to Sunico and situated in Denmark in order to secure payment of the revenue's claim for damages, which corresponded to the amount of VAT claimed to have been lost by the revenue. And that's why Lord Collins says at 5492 in the second paragraph that this was, in his lordship's view, an inadmissible claim for the indirect enforcement of foreign taxes. That's how he puts it in the second paragraph, after saying it's a surprising result. And I don't quarrel. I'm very unwise to quarrel with Lord Collins in relation to anything, but certainly not in relation to this. I see the force of his point that in English law, this would be a claim indirectly to enforce taxes which were due and had not been paid. But that doesn't help, my friends, in my respectful submission. Mr. Beale, my friend, then referred the court to cases concerning the missing trader intra-community fraud principles. He took your lordships to Mobilix, Total Network, and NatWest and Bilsa. And it is my submission that none of these authorities assists in resolving the issues in the present case. And that's for three reasons. The first reason is that none of the cases was concerned with the revenue rule. None of the cases addressed the revenue rule, either its criteria or its application. The second reason why these cases, in my respectful submission, do not assist is because they all concern claims in the context that tax had been evaded by taxpayers closely linked to the litigant. That is the missing trader. And there's a description of missing trader intra-community fraud in the total network case by Lord Hope, paragraph 4. That's Authorities tab 55, page 4280, page 4280. And whilst it is true the claim by the revenue is made against someone who does not themselves owe tax, the purpose and the effect of the claim is to recover unpaid tax that is due from someone associated, closely associated with the defendant. And therefore, it may well be, if the revenue rule were to be considered, it would be a case of indirect enforcement of tax due. But the cases don't address that. But it's the second reason why the cases don't assist in the present context. And there's a third reason why the cases don't assist, and it was the factor to which my Lord Richards drew attention yesterday. The cases were concerned with specific statutory regimes and directives relating to VAT, which of course imposes a charge at each stage in the chain of production of goods and services. So I do respectfully submit that those cases do not assist Mr. Beale in the present context.
Lord Pike, in considering whether this is a true analogy, whether these VAT cases provide a true analogy, is it appropriate to ask whether there was a tax relationship
In the present case?
present case, and as there undoubtedly was in the VAT cases, because they were all registered as traders?
Well, my answer to your Lordship is yes. My submission is that there was no tax relationship in the present case other than the purported relationship created by the very misrepresentations on which the claim is founded. We had no tax relationships with the relationship with the applicants. They were outside the scope of the tax regime, and that's a further reason both for distinguishing the VAT cases, but also a further reason for concluding that the claims which we bring against them are not claims for taxes due.
But the existence of a tax relationship would be a very open-ended and ill-defined test. I mean, your case essentially is a bright line case. Is there unpaid tax that is being claimed?
That is the criterion on which I found my case, but
Yes.
I'm suggesting to the court in answer to my Lord Lloyd Jones that in answering that question, is this a claim for taxes due, it may assist to ask the question whether there is some form of tax relationship between the revenue bringing the claim and the person against whom the claim is being brought. And if there is none, which I say is here the case, that may assist the court in answering the determinative question, which is the bright line question. Is the claim a claim for taxes due?
Yes.
That's how I put it.
Yes, I can see.
I'm not resiling from the criterion, far from it, but I sought to advance.
Your point is the one we discussed earlier, that they are impersonating taxpayers,
Yes.
and they aren't taxpayers, if your case is right.
On the basis of our case, they're not taxpayers. They have purported to be so, and Mr. Beale's case is heavily founded upon our response to his client's alleged misrepresentation, negligent, fraudulent, whatever it was, which I say cannot possibly provide the basis that he seeks to establish on which to elevate his contention that the revenue rule applies. And I give the same answer to the broader arguments which my friend raises on a broader sovereignty rule. I should just say that that is my answer to ground one of the appellant's three grounds. I say with great respect, ground one is unsustainable. Mr. Justice Andrew Baker erred in law in concluding that the revenue rule applied, and the Court of Appeal, for the reasons I've sought to advance and for the reasons they gave, correctly concluded that the revenue rule did not apply. That's my answer to ground one. Unless I can assist further on that, can I turn to the ground two, which is the appellant's reliance on a broader sovereign powers argument under Dicey Rule 20, subparagraph 1. And as I understood my friend Mr. Beale to accept, there's a very considerable overlap between his arguments on ground 2 and his arguments on ground 1. And I do submit that if we, SCAT, are right that the revenue rule does not apply, we do submit that it would require exceptional circumstances for a claim by a tax authority nevertheless to amount to a purported exercise of sovereign authority. The whole point of the revenue rule is to identify those cases in which a claim by a foreign tax authority does amount to a purported exercise of sovereign rights. And indeed, that's what Viscount Simmons said in Government of India. Could I take brought back to one other passage in Government of India? Its authorities, it's tab 1 of the authorities, page 1967 is where the law report starts. Authorities, page 1967. And the particular passage I have in mind is at it's authorities 1983. And at the top of the page, Viscount Simmons is dealing with a particular argument which I think has no relevance to the present case. But what he says, I submit, is of relevance. At the top of 1983, I am little disposed to introduce so nice a refinement into a rule, that's the revenue rule, which has hitherto been stated in terms that are easy to understand and to apply. My Lord Hodge mentioned to me a few moments ago that that's the one, it may be said to be one of the attractions of the revenue rule, that it is clear and precise. And if that's right, and if we are correct that the revenue rule does not here apply, I say this court should be very slow indeed to recognise that what does not fall within the revenue rule is nevertheless an exercise of sovereign authority by SCAT in bringing this claim. And the same arguments apply. SCAT is not seeking to recover tax due, it's seeking a remedy for misrepresentations by the appellants in the context of the tax regime, but not this is not a claim to exercise sovereign power. And this was dealt with by the Chancellor in the Court of Appeal. Could we go back, please, to what His Lordship said for the Court of Appeal at key documents, page 168. His Lordship dealt with the sovereign powers argument at paragraph 129 on page 168 of key documents. the Chancellor said the argument by the alleged fraud defendants that the claim is precluded by the wider sovereign powers rule within Dicey Rule 3 is equally misconceived. In bringing a claim to recover the monies of which it was defrauded, SCAT is not doing an act of a sovereign character or enforcing a sovereign right, nor is it seeking to vindicate a sovereign power. Rather, it is making a claim as the victim of fraud for the restitution of monies of which it has been defrauded in the same way as if it were a private citizen. We respectfully adopt that.
Yeah, so the distinction, I think, in some of the cases was made between a claim for breach of contract on the one hand and the exercise of sovereign authority.
Yes.
And you're saying this is essentially just a claim for tortious behaviour?
Yes, it is. And what matters is the nature of the claim. The question is not whether one can identify at stages in the past exercises of sovereign power by the claimant. I mean, plainly, there have been exercises of sovereign power. Denmark set up the withholding tax scheme and it applied it. But this claim is not an exercise of sovereign power.
It can't be. It can't be confined to looking just at the claim, because if there are indirect ways of collecting revenue, for example, there may be indirect ways of exercising sovereign power.
Yes.
But in this case, you come back to the earlier point that you're not dealing with a taxpayer at all.
Oh, indeed.
So how can this be an exercise of sovereign power?
Indeed. The reason why I focus, I respectfully agree with you, Lordship, the reason why I emphasise claim is because that was the emphasis given by the Court of Appeal in the Umbasogo case, which is the authority upon which my friend founds his submission. Perhaps we should just go back to Umbasogo, which is in Authorities tab 4, page 2, Authorities page 2048.
Sorry,
2048.
Thank you.
Umbasogo and Logo Limited. Of course, a very different context from our circumstances. As the court saw, the President of the Republic of Equatorial Guinea and the state itself were bringing private law claims for damages arising out of the alleged acts of the defendants in support of a failed coup d'etat. And as the court held, the claim in that case sought to vindicate the national security interests of the foreign state through the English courts, which was classically a sovereign interest. I have no quarrel with anything that was said in that respect. At paragraphs 22 through to 27 of Umbasogo, pages, authorities 2066 to 2068, there's an analysis of the very familiar case of Emperor of Austria and Day and Kossuth, and at 2068 paragraph 27, the Court of Appeal say, although this is on, 2068, although the actual decision has given rise to criticism and puzzlement, it is an authority which recognises the fundamental distinction between an action which amounts to the exercise of sovereign authority in the territory of another and an action brought to protect property rights such as might be brought by an individual. It's this distinction which founded the dismissal of the first two grounds of the bill, which related to the protection of Hungary from revolution, and the upholding of the third ground, which the court viewed as merely relating to the protection of property. That was the banknotes. It's moreover a distinction supported by Dr. Mann, as Francis Mann, and it is in the court's view a key distinction on the facts of the instant case. And there's then reference to what Dr. Mann had written at paragraph 41. There's a reference to the distinction between acts iure imperii and others, and at 42 and 43 there are references to Dr. Mann's writing, and at 42 Dr. Mann's suggestion where the foreign state pursues a right that by its nature could equally well belong to an individual, no question of a prerogative claim arises, and the state's access to the courts is unrestricted. Thus, a state whose property is in the defendant's possession can recover it by an action indebting you. A state which has a contractual claim is at liberty to recover the money due to it. If a state ship has been damaged in a collision, an action for damages lies. On the other hand, a foreign state cannot enforce in England such rights as are founded upon its peculiar powers of prerogative. Claims for the payment of penalties, for the recovery of customs duties, or the satisfaction of tax liabilities are the most firmly established of this principle, and to like effect, paragraph 43. And if your lordships want the writings that are mentioned at 42 and 43, the article at paragraph 42 appears behind tab 119 at 5530, and the article referred to at paragraph 43 appears behind tab 121 of the authorities at 5570. I won't take time on that. And at page 2075, the court expresses its conclusions of principle. Paragraph 50, after referring to Sir Sidney's submissions, they say in the second sentence of paragraph 50, the critical question is whether in bringing a claim, and I emphasise those words, a claimant is doing an act which is of a sovereign character or which is done by virtue of sovereign authority, and whether the claim involves the exercise or assertion of a sovereign right. If so, then the court will not determine or enforce the claim. On the other hand, if in bringing the claim, the claimant is not doing an act which is of a sovereign character or by virtue of sovereign authority, and the claim does not involve the exercise or assertion of a sovereign right, and the claim does not seek to vindicate a sovereign act or acts, the court will both determine and enforce it. That was the broad distinction of principle in Emperor of Austria. So that's the statement of principle, and the Chancellor referred to that paragraph in his judgment in the present case at paragraph 126, which is key documents, page 167. And I say the claim in this case is a claim which could equally have been brought by an individual to recover losses. We're not seeking, as I've said, to recover taxes due. Like any other victim of fraud, we are seeking a remedy to recover that which has been wrongfully misappropriated from us. Our submissions on the inapplicability of a wider sovereign authority principle are again supported by United States authority, because there is authority that a claim by a public authority to recover sums wrongly paid out in the exercise of official state functions is not of itself a sovereign act. And there are two cases. The first of them is the Nordrhein case, which appears behind tab 77 at page 4710 of the authorities. Tab 77, page authorities, page 4710, and it's a satisfactorily brief judgment of the appellate division of the Supreme Court of New York, decided in 1962. And the judgment for authorities 4710 explains the context. In the first paragraph, we see that the plaintiff, second sentence, the plaintiff is one of the federated states of the Federal Republic of Germany. In the second paragraph, we're told that the litigation stems from the enactment by the Federal Republic of Germany of a so-called federal indemnification law, which was designed to afford a measure of compensation for damages suffered by victims of Nazi persecution. Administration of the law was entrusted to the respective federated states. The defendant, who was now a New York resident and citizen, had formerly been a German national residing within the territory of the plaintiff, that is one of the federated states. And he filed a claim with the plaintiff's indemnification office, and he was granted awards, he was paid out. The next paragraph tells us that Section 7 of that law authorised the denial of a claim if the claimant, in order to obtain indemnification, utilises improper means, makes, causes to be made, or permits to be made, intentionally or through gross negligence, false or misleading statements concerning the basis for or the amount of the damage. Denial for such reasons is also permitted after determination, and the return of performances already rendered may be demanded. After payment of the defendant's claim, the plaintiff received information from which it concluded that in his application, the defendant had intentionally, or at least grossly negligently, misrepresented material facts. Accordingly, the plaintiff, through its indemnification office, issued a so-called revocation award, which was served on the defendant, and they wanted their money back. Over the page, some 6 lines down on page 4711, the complaint states 2 causes of action. The first founded on the revocation award, the second sounding in fraud.
Sorry, can you help? You're on page 4.
I'm on page 4711, and I'm in line 6.
Yes.
So first new paragraph, third line of that. The complaint states 2 causes of action. The first founded on the revocation award, the second sounding in fraud. Special terms disposition, that's the lower court, was grounded on the first cause alone, and we may confine our consideration similarly. And then further down the page, in the penultimate paragraph, just above the numbering 148, granted such submission, our courts may nevertheless decline to recognise determinations of tribunals of foreign countries if they contravene our public policy. We find no contravention here. While plaintiff is a sovereign, its aim is merely the restoration of an outlay wrongfully obtained from it. The object of the action is not vindication of the public justice, but reparation to one aggrieved. And we say that chimes with our submissions here. This is not a case where we are seeking the vindication of any sovereign authority. We're seeking compensation for the wrong done to us by reason of the misrepresentations. And that was so, said the New York court, irrespective of whether fraud could be established, because that was the second basis for the claim.
And it was also so, despite the fact that the claim pursued was for an award obtained under the same statute.
Precisely.
Under the...
Precisely so. So there were clearly sovereign acts, or acts which could be described as sovereign. There was the decision to set up the scheme. There was the decision to pay out under the scheme. And there was also what may be said to be a sovereign act, which was the revocation decision. But the New York court says, and we respectfully adopt what they say, and we respectfully agree, that nevertheless, if you look at the nature of the claim is not an exercise of sovereign power. It's a claim to recover that which was wrongfully extracted from the authority.
And that's a decision they reached without looking at the issue of fraud.
Indeed so. Indeed so. They didn't need to reach any question of fraud, as they explain at the top of page 4711.
Yes, because what you're reading opposite 148 is their examination of the first ground.
Yes, indeed. Well, they make that clear because they say at the top of page 4711 in line 8 or 9, the special terms disposition was grounded on the first cause alone, and we may confine our consideration similarly. So they're not addressing any question of fraud.
It's really based on the revocation of the award. It's the restitution of those funds.
Reparation to one aggrieved, as they put it. In other words, you're the victim of a wrongful extraction of funds from the authority.
But they claim not to be looking at fraud in that respect. Yes.
Irrespective of whether it was fraudulent, what is sufficient? What is sufficient was that the defendant, according to 4710 at the bottom, had misrepresented material facts. In other words, he wasn't entitled to the payout.
Yes.
That suffices. And the claim to recover that to which he was not entitled under the statutory scheme is not an exercise of sovereign authority. It's a civil claim simpliciter.
So you would say that even if, and I'm not sure what the answer is, Danish revenue law contains provision for making precisely this sort of recovery from a domestic recipient of a wrongful refund, that makes no difference.
It makes no difference. Danish law doesn't, and I'll show your lordship that in a moment, but it makes no difference. We're concerned with the nature of the claim that we are bringing. That decision was approved by the New York Supreme Court Appellate Division in a later case. That, as I said, was a decision in 1962, and it was cited with approval in 2014, as we see from tab 72 of the authorities, page 4685, case of Harvardsky and Kozany, and we see the context here from the headnote on authorities page 4685. A foreign judgment creditor commenced action seeking recognition of a judgment of a Czech criminal court that had directed a company's former officer to pay damages to the company as compensation for damage to the victim for the officer's fraud. And in the left-hand column, at the bottom of the left-hand column, there's a bit more detail. A Czech court order directing a former officer of a company to pay approximately $410 million to the company he was convicted of defrauding was not a fine or other penalty, and thus the foreign court judgment was enforceable in New York, even though the judgment was rendered by a criminal court, where purpose of the judgment was to compensate the victim for actual damage. And on the right-hand column, some 8 lines up from the bottom on 4685, the defendant argues that because the judgment was rendered by a Czech criminal court, it's not civil in nature, it's unenforceable as a fine or other penalty. And the court dealt with that relevant to our proceedings at authorities 4687. In the left-hand column, near the bottom of the page, there's the figure 243, so it's page 243, and just above that, if your lordships have that, we observed that even though the plaintiff was a sovereign, its aim is merely the restoration of an outlay wrongfully obtained from it. The object of the action is not vindication of the public justice, but reparation to one aggrieved, and that's a citation from the Nord-Rhine case, whereas here the purpose of a monetary judgment is to compensate the victim for actual damages. It represents reparation to one aggrieved, regardless of whether or not a particular damages award may be said to constitute a penalty. So there's an approval of Nord-Rhine more recently. So I rely upon those United States authorities. The appellants address those cases at paragraph 77 of their written case, and they say neither case was concerned with revenue law, which of course is true, but it with respect misses the point. The issue addressed by the New York courts was whether sovereign authority was being invoked. And as I've submitted, even though in Nord-Rhine the funds were paid out under a foreign state-funded compensation scheme, the claim to recover an overpayment due to misrepresentation was not considered to be an exercise of sovereign authority. Mr. Beale emphasised that no private citizen could operate a withholding tax refund scheme, which of course is right. Again, with respect, it misses the point. What matters is the nature of this claim. SCAT, in my submission, I'll take your lordship to the references in a moment, has no power under statute to recover the monies paid to the applicants, and in any event, it's bringing a civil law claim relying on the same private law rights any individual would enjoy to seek reparation to one aggrieved by a civil wrong. And it doesn't help the appellants to be able to point to sovereign acts that exist in the general context of this claim. Nor, in my submission, can the appellants rely on the fact that a decision was made to pay the refunds to the applicants. And first, that's because the decision to pay out was the result of the applicant's own misrepresentations on our case. The applicants cannot seek, and the appellants cannot seek to take advantage of their own wrong. That's the Chancellor, paragraph 136 of the Court of Appeal judgment. In any event, SCAT is not seeking by this claim to vindicate the payments out. Indeed, far from seeking to vindicate the decisions to make payments out, we are disavowing those decisions as based on misrepresentation. See the Chancellor, paragraph 130 of the Court of Appeal judgment, and 137. The way in which my friend puts the case, that there was a decision to pay out, also proves too much in my respectful submission. Is it the appellant's case, I ask rhetorically, that if Scat had paid a refund to Mr. A in the mistaken belief that he was Mr. B, the mere fact that there was a payment out means that the claim to recover the mistaken payment falls within the sovereign authority rule? My submission, no. No reason at all why the claim should be considered to be an exercise of sovereign authority. And one can think of other examples where a decision is made to pay out, but it would be very surprising indeed if it were the case that Scat were unable to recover because of a sovereign authority principle. I mean, supposing the recipient of the refund has bribed a junior official, or a more extreme example, suppose the recipient of the refund has threatened a junior official, put a gun to their head, with the consequence that the junior official produces a recommendation to senior officials that this payment out should be made, and the payment out is made. Is it really to be said by the appellants that the claim to recover, Scat's claim to recover, is an exercise of sovereign authority? That, in my respectful submission, would be a very, very surprising conclusion. But if the claim in those circumstances were not, I submit must be the case, an exercise of sovereign authority, why is it different if the payment of the refund was the result of a misrepresentation, perhaps a fraudulent misrepresentation, by the person to whom the payment? Scat's pleaded case, and it may not much matter, but just for the sake of accuracy, Scat's pleaded case is that the revocation of the decisions to pay out does not entitle Scat to claim back refunds under Danish tax law, and indeed nor have there been any proceedings brought by Scat to that effect. And the court will see this in the appendix, tab 23. Which begins at appendix page 951, and this is the re-amended reply from Scat to the defence of Mr. Knott and Mr. Hoogworth. And it appears in the re-amended reply to those defendants because they had raised this point. Can I show the court where the matter is dealt with? First, in the appendix, if the court has appendix 951, re-amended reply, if the court please would look at page 953, and we're in paragraph 5.1b on page 953. 5.1b, it is denied if alleged that SCAT's claims seek to enforce the revenue laws of Denmark. In particular, there's no unpaid tax or unsatisfied tax debt due under Danish revenue law from those defendants, or for the avoidance of doubt, any other defendant or the WHT applicants. And two, SCAT is not entitled under Danish law to issue a tax assessment to those defendants, or for the avoidance of doubt, any other, or make any other public law decision obliging them under Danish revenue or public law to pay the sums sought in these proceedings. And that's our pleaded case. And to like effect, in the same document, at page 989, at the top of page 989 of the appendix, paragraph 54, as to certain paragraphs, it is denied that any tax is due to or claimed by SCAT. In particular, it's denied if alleged that SCAT's preliminary and final decisions, which annulled SCAT's decision to accept the applications, and the subsequent challenges to those preliminary and final annulment decisions in Danish administrative proceedings, do or could give rise to any liability on the part of the WHT applicants to pay tax or any money to SCAT, save potentially in respect to the legal costs of those administrative proceedings. The administrative proceedings were brought by the applicants who were challenging the annulment. So that's our printed case. And we say further at 986, 986, paragraph 46.2, whether such decisions, that's the decisions to accept the applications made by the applicant, whether such decisions were valid and effectual under Danish administrative law is immaterial to SCAT's ability to bring its claims under both English and Danish law. And then B, the last four lines, further, as a matter of Danish law, SCAT's civil claims are not predicated upon and can be brought independently of SCAT's decisions to annul or reverse its decisions to accept the WHT applications. I don't suggest that any of that is crucial, but that is our position. And indeed, no proceedings, no tax proceedings, no public law proceedings have been brought.
Would you say if the Nordheim and Rosenthal principle is, albeit stated offshore, principle of English law as well, you don't need to go there?
No. And I'm not suggesting that this is central to our submissions, but the question was asked whether or not we could bring public law proceedings. Yes. And the answer, if it matters, on our case, is no. None of the provisions in the Withholding Tax Act confers a right to recover overpayments. And the Chancellor noted this in his judgment for the Court of Appeal, key documents, page 171, paragraph 141. I won't take time on that, but that's noted by the Chancellor. And your lordships were taken to parts of the correspondence yesterday. If and to the extent that any of the correspondence suggested otherwise, then my submission is it was wrong to do so. And no proceedings have been brought by SCAT pursuant to public law to recover the sums that were paid out. So I submit that the broader sovereign powers limb of Rule 20 does not assist the appellants for the various reasons I've given. My Lords, in the Court of Appeal, we reserve the right to argue in this court that Umbasogo was wrong with respect to conclude that there is a wider public powers dimension, that is broader than the revenue rule and penal laws. And your lordships may have noted that in Umbasogo, the appeal committee of the House of Lords gave permission to appeal. One sees that in the law report, authorities, it's at page 2087. 2087, my lord. Just check that. That's right. Umbasogo is tab number 4.
Lord Bingham, Lord Roger and Lord Carswell allowed petition to
Indeed.
appeal.
So permission to appeal was granted, yes, 2087 of the authorities. And my understanding from public documents is that an appellate committee was instituted to hear the case. I'm told nine members of the appellate committee, no doubt because of the importance of the issue, and the hearing started, but the proceedings were then aborted because of, according to the public documents, because of the difficulties for the defendant who was detained in Equatorial Guinea to obtain access to his lawyers, so the case did not proceed. And we reserved the right to argue that Umbasogo was not correctly decided in the Court of Appeal. We note that in the Ortiz case, which is in the Court of Appeal, it's authorities 2478, Lord Justice Ackner doubted that there was a wider public law category. I'm not submitting to this court today that the court needs to decide that question. I'm not proposing to argue that question, because my submission is that if there is such a wider category, it is at most a limited one covering cases such as Umbasogo, where the claim is clearly an assertion, the claim is an assertion of sovereign authority, their damages for promoting a coup d'etat. And on any view, this is not such a case. And I hope that's an acceptable way for me to make my submissions. There's a further point my friend argued in relation to this wider sovereign powers argument. It was, he said, SCAT has used public powers to obtain evidence in the present case. In my submission, whether our claims fall within the scope of Dicey Rule 20 is a question of characterisation of the substance of the claims which we are bringing. And the use of powers of investigation is at best of peripheral significance in that respect. And indeed, any suggestion to the contrary would be inconsistent with what I would describe as the general indifference of the English court as to the manner by which a party has obtained relevant evidence, save for the exceptional circumstances of evidence obtained by torture. That is in a category of its own. But apart from that, the court generally is not interested in the means by which evidence was obtained. I mean, the means may assist in relation to the strength of that evidence, possibly its relevance. But I say in this context, whether a claim is a claim for in exercise of sovereign powers is marginally, if at all, assisted by reference to any use of investigation powers. And in any event, we emphasise that in the proceedings we're bringing, SCAT has no privileged status, and nor does any evidence which it adduces have any privileged or special status. And indeed, the evidence we have obtained has been disclosed in the normal way, and it can be used to the extent that it assists by the defendants in the proceedings. Again, this was a point that the Chancellor addressed in his judgment for the Court of Appeal. He addressed it at the end of paragraph 142 of the Court of Appeal judgment at key documents page 172. It's the last 4 lines of paragraph 142 of the Court of Appeal judgment. That SCAT has been open with the alleged fraud defendants as to the information it has obtained. It's not sought to use it in these proceedings so as to give itself some special advantage only available to a sovereign body. It's not made some binding determination which has a special evidential effect in these proceedings. And indeed, the principle of English law since at least 1833 is that when a monarch or a state sues in a private capacity before the English courts, it has no privileged status. That's the King of Spain and Hullet. Perhaps we should just look at that very briefly. It's behind tab 38 of the authorities. And the report begins at authorities 3616. It's the case of His Catholic Majesty Ferdinand VII, King of Spain and the Indies, against J. Hullet and C. Widder, 1833. And the relevant passage in the judgment of the Lord Chancellor Lord Brougham is at 3628, and at 3628 of the authorities in the 3rd paragraph on the page, beginning, "Is there any instance?" Your Lordships have that some 6 lines down in that paragraph, beginning, "Is there any instance?" The Lord Chancellor says, "The right of the King of Spain in respect of privilege in the courts of England is not greater than that of any of his subjects. If he can bring his privilege with him, why not may his subjects also? One objects to answer upon oath, another may object to a trial by a jury of tradesmen. But if the king is recognised in the character of a suitor, must he not be content with the common fare of the court?" And then 2 paragraphs further on, the Lord Chancellor, in line 4, "The King of Spain here sues here by his title of sovereign, and so he must be sued if at all. But beyond the mere name of sovereign, it has no effect. He brings with him no privileges which exempt him from the common fare of other suitors." Salutary principle. So my clients have no special privileges when they bring their claim. They must prove their case like any other litigant. My Lords, if those submissions were not to be correct, and your Lordships were to think that there is here an exercise of sovereign authority in bringing the claim, then we say, finally, on this part of the case, that there is a public policy exception to the wider sovereignty rule. The court will not decline to hear the substance of the case, notwithstanding that there is an exercise of sovereign authority, if that would be contrary to public policy. And that principle is set out in Dicey. Perhaps we should just look at what Dicey says. It's behind tab 11 of the authorities, and we find Dicey begins at 2348, authorities 2348, and the relevant passage is at 2365. And it's at the top of page authorities 2365. It's paragraph 8-021 of Dicey. Dicey, Morris and Collins. The result of the authorities in the Court of Appeal is that the English court will not enforce a claim based on foreign public law if the claim involves the exercise or assertion of a sovereign right, unless it is contrary to public policy for the claim to be shut out.
I'm slightly puzzled by the footnote.
Footnote, which one, my lord?
It's supported by footnote 87,
Yes.
which refers to a couple of paragraphs. I think it's probably because we're just on a particular page and need to look back. Yes.
Yes, I mean, the relevant authority is the Iran case.
Yes.
It may be unclear whether that's what the footnote, because
I think it's a reference back to the case at footnote 85.
yeah,
Which is the Iran case.
it's the paragraphs. Yes, it's the paragraphs in the Iran case. Can we go to the Iran case? Yes, indeed, particularly 154. The Iran case appears behind tab 2 of the authorities, which starts at authorities page 1992, and this is a case, as the court sees from the headnote, where the Iranian government were suing a defendant art gallery trading in antiquities, seeking the return of certain antiquities which the Iranian government alleged had originated from excavations in Iran and to which the Iranian government was entitled under Iranian law. The issue of and the argument was whether or not the claim was an exercise of sovereign authority, and the court said no in that case, and the court went on to consider in any event whether there was a public policy defence, and the court began to address that at page 2033 of the authorities, where they say at paragraph 151, if we're wrong in the view that this is not a claim to enforce foreign public law, then we do not consider that it should be precluded by any general principle that this country will not entertain an action whose object is to enforce the public law of another state. There's a lot of knots there, but they're recognising a public policy defence. And they say at 154, in our judgment, there are positive reasons. I should just have drawn attention to the composition of the court. It was Lord Phillips, Chief Justice, Lord Justice Wall, and Lord Justice Lawrence Collins. 154, in our judgment, there are positive reasons of policy why a claim by a state to recover antiquities which form part of its national heritage and which otherwise complies with the requirements of private international law should not be shut out by the general principle invoked. Conversely, in our judgment, it is certainly contrary to public policy for such claims to be shut out. And then the court went on at 155, paragraphs 155 to 163, to address the public policy considerations relevant in that case. Although the analogy is far from perfect, I accept, your lordships will know my Lord Lloyd Jones has given recent judgments on the subject, that in the context of the doctrine of foreign act of state, there is a public policy exception, and one doesn't need to go into, for purposes of this case, the extent of that. It's a complex matter, but in that context, a public policy exception does apply. I accept, as I've said, because Lord Temperament so stated and other authorities agree, that the narrow revenue rule is not subject to a public policy exception. But as the Court of Appeal recognised in the Iran case, the position is different in relation to the wider principle of sovereign authority. Why is that? Well, because the issue under the revenue rule is clear and it's precise, it's narrow in scope. And the nature of the rule is that the claimant is seeking, directly or indirectly, to recover tax which is due. And in that context, a bright line rule is thought to be appropriate. By contrast, to the extent that there is a wider sovereign powers rule, then, as the Court of Appeal found, the Court will balance all relevant considerations and consider public policy. My Lords, our case is that if, contrary to our submissions, this is a case of the exercise of sovereign authority in the bringing of the claims, we say that the claim should not be excluded. The claimant should not be excluded from seeking a remedy in this jurisdiction for public policy reasons. And the public policy reasons, in essence, are that the allegation is one of fraud. And we've referred to authority that fraud is a thing apart. We say it would be contrary to public policy to allow alleged fraudsters in this country to target foreign public authorities as attractive targets without the ability of that victim to seek to recover its losses. We also draw attention to the facts on our case that the representations on which we found our claims were made from this country. A large number of the individuals who participated were resident here or British nationals or both. And the majority of the refunds paid out were received into bank accounts held in this country. And we do submit that when the court is being asked, as it is by my friend, to apply Dicey Rule 20, subparagraph 1, in a context well beyond the scope of any previous case, the court should take into account these public policy considerations and decline to extend the rule. In the Court of Appeal, the Chancellor said he recognised the force of this submission but did not need to decide it. That was paragraph 146 of the Court of Appeal judgment, key documents, page 173, paragraph 146. He didn't need to decide it because this was not a claim in exercise of sovereign authority. But I repeat the submission if I need to. My Lords, that's our submission in answer to the appellant's ground 2. I say that the Court of Appeal correctly found that a wider sovereign powers principle does not apply in the circumstances of this case. It's very unclear, if I may say so, whether Mr. Justice Andrew Baker decided the case on that basis. If he did, he was wrong in law to do so. And that's our answer to ground 2. My Lords, will that be a convenient moment to break for the adjournment? I need to deal with the international agreements on which my friend relies, and there's a couple of other points that I will certainly finish by 3:30. I hope to do better than that.
Thank you very much, Lord Panic. The court will now adjourn.
Thank you.